This is Don Brown. Now, today I want to lay out in no uncertain terms exactly why Jack Smith's prosecution of Donald Trump violates federal law on multiple counts. Please feel free to take notes and let's make this go viral when we're done. Now, first off, this prosecution of the president by Jack Smith violates two specific United States statutes, which should cause immediate dismissal of the action. And as far as I'm concerned, discipline against the prosecutors themselves. The first is the Presidential Records Act. You may have heard of this. President Trump spoke about this just the other night when he was talking to the Religious Broadcasters Group, or the Religious Faith and Values Group, excuse me. I want you to write this down. 44 U.S.C. Section 2205, parentheses 3. 44 U.S.C. Section 2205, parentheses 3, gives a former president, not just a president, but a former president, absolute right. All he wants to have access to his presidential records. And not only that, but it gives that president the right to designate certain agents or assistants to have rights to those records. Now, Smith is trying to claim that once President Trump left the White House, that he had no more access to classified materials. This simply is ridiculous and it's bogus. The Presidential Records Act gives a former president, and he uses that phrase, access to all of his presidential records, those which were secret, those which were top secret, those which were classified, those which were eyes only. There is no distinction. I want you to think about this. A few years ago, former Admiral William McRaven got upset with President Trump. McRaven is a liberal Obama appointee who was the admiral who was in charge of the SEAL Team 6 mission against bin Laden. He got upset because President Trump decided to revoke the security clearance of former CIA Director John Brennan. McRaven wrote this long railing op-ed in the Washington Post attacking President Trump for revoking Brennan's top secret security clearance, even though Brennan had been out of office for a number of years. Well, think about it. We are giving former CIA directors and other federal officers almost unlimited access to classified materials after they leave office. But a former president doesn't have access to such materials? It makes no sense. The president is elected by the people. These CIA directors and deep state operatives are not. And the Presidential Act gives him absolute access to all of his presidential records, secret, top secret, or otherwise. Also, the Presidential Records Act does not restrict the time, place, and manner under where this access can take place. Jack Smith is trying to make a big deal over the fact that the president had the records at Mar-a-Lago, just like Barack Obama said had some of his records in Chicago. Just like in the famous Bill Clinton Sox case, Bill Clinton had taken certain recordings out of the White House and had them in his own personal residence. The Presidential Records Act does not restrict where the access to the records can take place at all. It could be in Washington, it could be in a secure vault, as we used to have to go into when I was in the Navy, or it could be at Mar-a-Lago, or it could be in Tahiti. It could be anywhere in the world. There is no restriction under the law. So the fact that the president had these documents, which were his records at Mar-a-Lago, is nothing but a red herring. It's not restricted. In fact, the only time the Presidential Record Act really even talks about classified materials is that it gives the head of the National Archives the ability to declassify certain records. And that's it. But it does not prohibit the president, the former president. And he uses that phrase, by the way, former president. Smith has tried to argue that when Trump left the White House, he's a former president and has no longer access to classified information. That is a lie from the pit of hell. Under the Presidential Records Act, he's got access all day long, and the phrase former president is used. Classified reference in that act only gives the National Archivist the ability to declassify certain records, but it doesn't prohibit the president or the former president from having access to those records. Yes, the National Archives could take possession of records that are deemed to be presidential records, whether those records are classified or non-classified, whether they're top secret or simply part of the president's diary that had to do with a meeting with the British Prime Minister that really isn't classified because it was out in the public. the archivist can take possession of presidential records, but the Records Act requires consultation between the former president and the National Archivist to see if they can make a determination as to what are presidential records versus personal records. If there is a dispute between the two, that is the former president and the National Archivist, then under those circumstances, here's what happens. Then under those circumstances, the archivist could file a lawsuit, a civil lawsuit, not a criminal lawsuit, a civil lawsuit in federal district court under which a federal judge would serve as a referee. Say, yes, this is a personal record, this is a presidential record. And if it's a presidential record, well, then the records can go to the archives. But even if that happens, the former president still has unlimited access to those records under the Act, secret, top secret, or otherwise. And this is what was going on between President Trump and the National Archives. They were negotiating over records, just as the Act contemplates. And then all of a sudden, out of the blue, here comes this Jack Smith with subpoenas. This has never happened with any other former president with regard to presidential records. And all the issues before have been worked out. There was a lawsuit filed involving President Clinton over the Sox case, and federal judge in that case said the archivist doesn't even have the ability to take possession of the records unless either the former president allows it or a federal judge orders it. There are no criminal provisions in the Presidential Records Act, and Jack Smith has totally ignored the act altogether in his bogus and kangaroo court indictment. Now, then Smith wants you to believe that President Trump has somehow violated the Espionage Act, which is what the prosecution in Florida is primarily built on, the Espionage Act. Well, the Espionage Act was designed for folks like the Rosenbergs who were compromisers of state secrets and who received the death penalty and who gave information to an enemy of the United States. Was never, ever envisioned or thought of to be applied against a former president who has access to his records anyway. But Smith doesn't want you to know that. You see, you and I, if we had unauthorized access to classified records, we could be subject to prosecution. We are not former presidents. Former presidents are in a different classification. There are only 4 or 5 former presidents alive. There's President Carter, who's still alive. We wish him well. There's President Clinton. There's George W. Bush, Barack Obama, and now President Trump. There are only 5 in the entire nation, and every one of them have access to their records, whether those are secret, classified, or top secret. So it is bogus, and the notion of using the Espionage Act as an excuse to prosecute this president, this former president, for having his own records should be sanctionable, and this action should be thrown out immediately. Now, here's a second federal statute that Mr. Smith is violating by bringing this action. It's called the Hatch Act. You may have heard of the Hatch Act. Generally, the Hatch Act prohibits federal employees from using their position and using their office to be involved in political campaigns. Federal employees can speak out on their own time and their own dime. They can vote for who they wish to vote for, but you can't clothe that with the accoutrements of your office. In fact, I want you to write this down as well. 5 United States Code 7323. 5 United States Code 7323, and go Google it. Look under section A1, 5 United States 7323 A1. And what you'll find there is, yes, federal employees can do what they want on their own dime, but no federal employee can use his or her office to in any way influence, interfere with, or affect the outcome of an election. Let me repeat that. A federal employee cannot use their office in any way to influence, interfere with, or affect the results of a national election. So let's ask this question. Anybody think Jack Smith's prosecutions that he's dropping here in the middle of election season might have the potential to influence, interfere, or affect the 2024 election? You have to be a zombie not to see that coming. That's coming a million miles down the road. Of course, that is exactly what is happening. And it can't stand, and it can't happen. Therefore, this lawsuit should be dismissed because it's a blatant violation of the law. You know, the Justice Department used to have a policy. They wouldn't even bring any type of action against anyone running an election season. That started to change a bit in the last few years. But the reason for that is because of what can and will happen. You think about it. Smith dropped this bomb on President Trump, not only after President Trump had declared for re-election, but after Biden had declared, after Bobby Kennedy had declared, after all the Republicans vying for the #2 spot, in my opinion, had declared: DeSantis, Chris Christie, Nikki Haley, Tim Scott, Vivek, the governor of North Dakota. You go down the line, they all had declared that they were running, and then boom, this indictment gets dropped. And not only that, but Smith is now looking for an excuse to bring another indictment. Tell me that any jury could not find that the timing of him using his federal office, both Smith and his boss Garland and their minions, that timing is not designed in any way, shape, or form to influence, interfere with, or affect the result of the 2024 election. It's impossible not to conclude that. This lawsuit is a violation of federal law now on a second federal act, that is the Hatch Act. It's a violation because it violates the president's protection under the Presidential Records Act. It's a violation because he's violated the Hatch Act. This lawsuit, this prosecution, should be thrown out on its ears. And finally, I want you to think about this. Smith's shenanigans in bringing these lawsuits are a violation of the United States Constitution. Not only the president's rights, but your rights as well. Let's talk about that. First off, dropping this lawsuit in the middle of the election season is clearly an attempt to affect President Trump's right to speak out as he runs for president. If you stop and think about it, the First Amendment prohibits the government from taking any action whatsoever. And federal prosecutions are not exempt from that prohibition because the right to free speech trumps all of that, prohibits the government from taking any action whatsoever to violate free speech. And in these cases, we see Jack Smith and his minions trying to go to these federal judges and getting gag orders against President Trump from even speaking up about this obvious political prosecution. That, my friends, is a violation of the First Amendment of the United States Constitution. This case should be thrown out based upon that, but it is not only the president's right to free speech that are being violated. If you stop and think about it, ladies and gentlemen, you and I and everyone who is registered to vote in the United States of America, when we go in to that ballot box in private and we cast our ballot, our act of casting a ballot is the ultimate and quintessential exercise of our right to free speech. We are freely choosing through our speech, through our communications on that ballot, who it is that we would like to have us be, to represent us as president of the United States. And what this prosecutor is attempting to do is to stop every supporter of President Trump or everyone who may support President Trump from having that right of voting in the 2024 election for the candidate of their choice. It's also a violation of President Trump's Fourth Amendment right. The Fourth Amendment is the great amendment that prohibits unreasonable searches and seizure. It talks about search warrants. And as it talks about search warrants, it says that with a search warrant, there's a particularity clause in there. What I mean by this, that the place to be searched and the objects to be searched for must be described with sufficient particularity so that there's no ambiguity as to what it is that these searchers have a right to go looking for. But in this case, this particular search warrant did not do that. In fact, it was very general. It said, go search for presidential records. Well, first of all, it isn't up to some FBI agent to determine what a presidential record is. Again, determination of presidential records can only come from the process set forth in the Presidential Records Act, not from a prosecutor like Jack Smith and not from an FBI agent that he goes and sends in. But that warrant also said to go in and find any government records. Now think about it, any government records. Now the Fourth Amendment says the search warrant must be particular in the item to be seized. But the phrase government records is about as broad as it gets. That could be President Trump's driver's license. It could be Melania's driver's license. It could be a birth certificate. It could be the motor vehicle titles in the cars outside in the lot at Mar-a-Lago. It could be almost anything, because this search warrant was overly broad and really was constructed to give these agents an opportunity to engage in a fishing expedition. All evidence seized under it should be immediately suppressed, and this case should be dismissed. Also, President Trump's right to effective assistance of counsel under the Sixth Amendment has been violated. These prosecutors, Smith and his minions, have put pressure on Trump's lawyers from the beginning. In fact, there's a group out there that Alan Dershowitz talked about, I think it's Project 65 or something like that. They're waging war on lawyers representing President Trump at every front. And so pressure gets put on these lawyers, and they say, hey, you cooperate with us and we won't bring you in as a conspirator. And then these lawyers turn and sing, like canaries going to the coal mine, I suppose. And in doing so, they turn over everything that's supposed to be, they turn over everything to the government, to Smith and his prosecutors, that's supposed to be protected by the sacrosanctness of the attorney-client privilege. Never should they turn those over, but their options are to go to jail if they don't, because they're going to try to go get a Democrat judge to hold them in contempt of court, maybe even prosecute them themselves. So the government forces Trump's lawyers to turn on him, taking away the president's Sixth Amendment right to effective assistance of counsel. The Supreme Court has said that the Sixth Amendment gives all Americans the right not just to counsel, but to effective assistance of counsel. So this prosecution violates the First Amendment, the president's rights, your rights, my rights. It violates the president's Fourth Amendment rights to a reasonable search and seizure. And what happened was unreasonable. It violates the president's right to effective assistance of counsel. It violates two statutes, the Hatch Act, and it violates also the Presidential Records Act. It violates the Constitution. This prosecution should be ended immediately, and those behind it should be dealt with appropriately. Please make this go viral. Our people need to know what the truth is. Thanks, and God bless.